Good afternoon, Dylan. I'm very well, thank you. How are you?
Cool. Yeah, very good. Thanks. Thanks for spending some time with us today. I was thinking about it, and we actually started speaking before Intanify was even really an idea. We had kind of a rough chat with you, and we said, what about this? And that's actually how our relationship with Mathys started through you. So it's actually kind of quite fitting to have this conversation with you. So thanks for making the time.
No, pleasure, pleasure.
Cool. So we know you obviously very well. I thought perhaps the best point of departure was just to hear from you a little bit about your practice and your background and what it is you do in patent law.
Sure. So my name's Max. I am a patent attorney. I'm a partner at the firm Mathys Squire, which is a UK, German, and European patent law firm doing all things to do with patents in all technical areas in those jurisdictions. I have a background in engineering, I was a mechanical engineering degree, but in practice I did a bit of everything including quite a bit of software. And I work with clients large and small on getting patents and using patents in those fields, in what we would call IT and engineering fields.
Cool. And with a fair amount of focus on AI, is that right?
Yep. These
Yeah.
days in particular, substantial focus on AI. Yes.
Yeah. It's almost what software is now.
Yep.
Cool. So yeah, on software patenting in the UK, it's often regarded, which I understand is a fallacy, that it's very difficult or impossible. But that's your job, so that's obviously not true. Why is it? And why do people think that?
Yes, it's an interesting one. As you say, it's a perception rather than reality. And I think that the reasons are basically historic in nature. There was a comparison with the US, which for a time was much more liberal, and the UK was sort of viewed unflatteringly, well, depending on your point of view, unflatteringly from the point of view of obtaining software patents in comparison. Um, what the law actually says is it defines certain categories um, of inventions that are excluded from patent protection, and what the words of the law say, that among other things, computer programs as such are excluded, or per se are excluded. And of course, it's all in that as such. A computer program just on its own, nothing more than a computer program, you can't get a patent for that in the UK, and that's still true. The difference, though, is of course that patent lawyers like myself would make the case that any given inventions, or any given invention that we can realistically make the case for, is more than a computer program as such. It's a computer program applied to a technical problem, and if we can successfully make that case, then the case law really clearly supports, and we see in practice we get hundreds of these granted a year, thousands of them granted a year probably, that you can obtain software patents in the UK. It's just from the point of view of the law, it's not a pure software patent, it's software
Mm.
applied in a technical way, or it's underlying technical aspects of software that make it more than just a computer program as such.
Yeah. So that's obviously very important, that technical word, and it's not easy to understand because when you say technical, I'm thinking, well, then it's only if my software is related to, some kind of engineering or drilling technology or something like that. So perhaps you could just explain a little bit more what technical effects actually is.
Well, it's a little deliberately difficult to understand,
Mhm.
sadly. The definition is left open in the law, and the idea behind that is because different things might become technical over time, and they don't want to be going in the UK going through Parliament to get new definitions of technical through every couple of years or something like that. It
Mm.
it is a tricky concept, and yeah, there are areas that are I think the layman would see as clearly technical, like controlling a drill bit or something like that, as you said, that indeed the law, the Patent Office also sees as clearly technical. But so yeah, as you've said, you can straightforwardly avoid these excluded subject matter problems, as we would call them, by trying to patent an invention that is a computer program used in control of a technical process or something like that. But there are, it's not merely that. You can also quite reasonably and successfully make the case in a lot of instances that that there are other technical effects. For example, that the computer effectively works better as a computer as a result of your program. It's faster, more efficient, more secure, or something like that. And in that case, the patent office, presuming you do enough to meet that standard, will consider that as being more than a computer program as such. It's something about your program related invention, or computer implemented invention, as we would usually call it as patent lawyers, that produces some kind of real world technical result. And the key to understanding that perhaps is that it's some sort of tangible advantage that is more than merely a business advantage, if I can put it that way, where a business advantage would be something like we can sell to consumers more efficiently or something like that.
Yeah.
And now where the sort of art and science of being a patent attorney lies is in cases like that, being able to come up with an argument that in fact there's something about the way in which you sell to your customers more effectively that actually has got some underlying technical advantage about it. Maybe the way in which you transmit data is in some way more secure, faster, more efficient, better throughput, better sort of structure of databases or something, producing some kind of real world technical result.
Yeah.
So I'm not sure I've straightforwardly answered your question, but I'm not sure I can straightforwardly answer your question, I'm afraid.
That's what keeps you in the business, right? But no, I think that's pretty clear. I guess we've kind of jumped straight into the weeds here, but that's fine. We can zoom back out again afterwards. The other tricky concept is novelty, because everybody feels their baby's the most beautiful, and of course everybody, particularly in kind of like a business context, feels that nobody ever thought of this before. But perhaps while we're in the weeds, before we step back out, you could talk us through novelty and what you think about for that.
Well, you'd be surprised about the baby is the most beautiful point.
Yeah.
What we find is that actually a lot of technical folks, a lot of engineers and software developers quite often underrate what they do in patent terms. They would see what they do as applying typical techniques in their field to a slightly different problem, and they would see that as unexciting and undeserving of a patent grant. And actually, a lot of the time they're wrong about that. The law is less restrictive than they perceive it to be. But coming back to your question, novelty is actually straightforward in a lot of ways. Novelty is simply it's absolute. It's spot the difference. Is there a difference between your invention and what has come before? If there is a difference, then you are novel. The difficulty is, of course, is that there are a lot of things that have come before, and it's about conceivably anything out there that's exactly the same that someone has been working on and has made public. If it is the same as yours, if there are no differences, or no differences to a certain level of abstraction anyway, then at that level of abstraction, you will not be able to get a patent granted for it. And I guess the complexity in that comes in that this standard applies all the time. So it's not as if when the patent office rubber stamps your patent as novel and satisfies all the other steps to such that it could be granted, there are still risks. Someone, a third party, say, could come up with some super obscure document that was published in a journal in Russia 20 years ago or something like that. That is still valid prior art, and it may render your patent application not novel. It's invalid, and so if it's challenged, it dies despite being granted. So that's a bit of complexity that a lot of times people don't appreciate. Just maybe if I could go a little bit beyond the scope of your question, there's sort of the novel, the additional step that we would, and the patent office would usually think about, but after novelty, is what we call inventive step, and what our American cousins call obviousness. and that is where things get a little bit more difficult. Novelty is just, is there a difference? Inventive step is that difference inventive enough to justify the grant of a patent? And this is where patent lawyers like myself sort of really prove our worth. And usually what you're looking for in satisfying inventive step is that you have solved a technical problem in a technical way that requires more than someone totally unimaginative in the field applying totally obvious techniques to make a broad generalization. And coming back to my point about engineers and software developers underrating what they do, the standard here is the reason why they underrate what they do is because they are smarter than the notional, totally unimaginative person skilled in the art, as we say in patent law, as it's set out in the legal tests, that applies totally standard techniques. So actually, in a lot of instances, applying a standard technique to a new problem, a new application, means you have novelty, and as long as that standard technique is adapted in a sort of exciting way, that means you have solved a technical problem in a technical way in making that adaptation, and you get some technical advantage out of that, then that should in principle be enough to justify the grant of a patent. So yeah, I could keep ranting on, but I feel like I've already gone well beyond the scope of your original question.
Yeah, well, that's an important difference, isn't it? And it's funny, the baby's the most beautiful point is coming from an entrepreneur and an ex-banker's perspective.
Yes.
Very different engineers who bless them, are probably far better people than my side. But so I can totally imagine that. So you've mentioned the US a couple of times. There, it seems to me, I mean, maybe not easier, but one might be able to get a patent for, you said that anything else purely business, so selling to a customer better. In the UK, you're unlikely to get that. In the US, you would be more likely to get that, or what are the key differences?
So in the US, for a long time, they were a lot more liberal than the UK and the European Patent Office, which we might touch on later, when it came to patenting software and or inventions that approach closer to this business method concept that we've talked on a few times. And indeed, sort of around the .com era, there were some quite notorious cases that gave the idea of software patenting quite a bad name among many software developers. There's in particular the infamous Amazon's one-click shopping patent, which was granted and successfully enforced, I believe, in the US, whereas it never got granted in Europe. But actually, these days things are not so different. Around 10 years ago, there was a decision called Alice, and other decisions called Mayo and Bilski. And following those decisions, practice now is really quite a lot closer to the UK and Europe. In fact, I mean, talking to many of our clients, there are complexities, there are different tests that are applied, but actually the difference is not so extreme if you can get through excluded matter objections in the UK in particular, because the UK is probably then you can probably get it in the US, and vice versa. If you can get something in through over these excluded matter objections in the US, you've got a reasonable chance. It's slightly stricter in the UK still, a reasonable chance of getting them through also in the UK, and in particular in the European Patent Office. So again, I think a lot of the reason why there's this perception that the US is easier exists is to some extent historic, I think.
It's amazing how much incorrect information there is around this topic. So just to close the loop there, on Europe, you said we'd get to it later, so we don't forget. What were the key contrasts with Europe?
So Europe, to avoid getting too hung up on the details, there are a lot of details here, sadly. Europe is patenting in Europe takes place via the European Patent Office, which is a institution that is actually separate from the European Union. So the UK is still in it, and indeed,
Oh.
if you wanted to get patent protection in the UK, you don't need to interact with the UK Patent Office at all. You could get a patent in Europe via the European Patent Office, and that would also cover the UK. The European Patent Office is well, obviously, it covers more than just the UK. It can be used to cover a wide variety of states in Europe, and in practical terms, the tests that they apply are slightly different to the UK. And that means that in some instances, we might recommend that clients go for the European Patent Office rather than the UK. The perception, which is probably true, is that they are a little bit more liberal on software and business method patents, but they're only more liberal in the sense that they quite rigidly apply a particular approach to recognizing what an invention is. And as long as it fits into their particular framework, you can be reasonably assured of getting reliable results. In the UK, things can be a little bit faster and looser, and sometimes that's a good thing, and sometimes that's a bad thing.
Yeah. Okay, interesting. Cool. So taking a step back, we went into the weeds maybe sooner than I would have planned. But what are the big trends that you see coming through your doors?
Well, you'll be unsurprised to hear that quite often new cases that come to us follow what you might call hyped trends in the media more widely. So right now, a couple of years ago, we were seeing a heck of a lot of blockchain, which we still see, but maybe a little bit less of it now these days. And right now, we see a lot of AI, machine learning related inventions.
Yeah.
Quite often, those are machine learning and AI applied to particular applications, but also we're seeing quite a lot of what you might call core AI machine learning inventions. So ones that are more about the fundamental way in which you perform AI machine learning related techniques. And both of those, to emphasize what we said earlier, are in principle patentable. It's the application related ones tend to be easier if the application is a technical one, but the core AI related stuff is also patentable. It's just that you need your patent lawyer to come up with an argument, effectively come up with an argument that takes whatever's been invented and slots it, decent case that it can be slotted into the relevant legal test to come up with a reasonable outcome and overcome any objections that are raised.
Yeah, so if you're using one of the big models that we'll read about to some particular business application, that almost certainly wouldn't apply. But if you had, or correct me if I'm wrong. Yeah.
Well, yes, I think you can be a little bit pessimistic in that kind of situation.
Sure.
If it's just applying a existing model to a non-technical business application, then unless some sort of related argument can be made, then your prospects are probably not that great. And even if it is a technical application, there's a question as to whether, if it's new, applying a well-known AI technique to a particular problem, there's a question about whether that's inventive, of course, particularly if there are other people out there applying the same AI models, let's say ChatGPT for something or other. Even if you're applying it to a technical question, a technical problem, there's a question about whether it's inventive or not.
Yeah, okay. But if you had built your own model or had made substantial changes to another model, you would be standing in better stead.
Yeah, indeed. Maybe the way to look at this is if you are making changes to existing methods, if you are solving technical problems in practically implementing it, that's the kind of thing that and solving technical problems does not need to be particularly exciting. It just needs to making it work in a way that is more than entirely straightforward implementation. And in cases like that, yeah, in principle, you should be able to get something patented. The question, of course, as always, is what is out there.
Yeah.
And we can never have perfect knowledge about what is out there. No one can. There's always something that could come out that's closer than what you had originally envisaged as being the closest prior art, and of course that can cause problems later on, further down the line.
Yeah, yeah. And so blockchain, I'm interested that you still get many inquiries on that. I had heard that it was relatively easy for blockchain related concepts because the UK IPO didn't really want to be bothered thinking about it too much. So, blockchain, you hear about it often of put it on the blockchain, apply this particular thing to the blockchain, which in a lot of cases makes a lot of sense. So example,
Yeah.
for supply chain and international shipping, you have, a port on either side, you got a shipping line, you got forwarders and so on, and they're all looking exactly the same thing. So it makes a lot of sense to put that on an immutable chain. Is that true, or is that kind of silly pub talk that it was easy to apply anything and therefore get a patent around it?
I would say that similar comments to those that I made a little earlier about AI apply.
Okay.
I would say that it's not really in particularly different from any other kind of computer implemented invention.
Yeah.
It's patentable if what you are doing is more than merely straightforward implementation. Just blockchain plus X in some kind of straightforward, straightforward standard way is probably not so exciting from the patent office's point of view. It's also probably worth mentioning that the first wave, if I can put it that, of blockchain application, blockchain for X's is we're probably past the peak of that first wave, which means that there is a fair bit of prior art out there as well. Whereas that we're still probably in the middle of that wave for, well, depending on who you ask, machine learning is not a new technique. There's previous patent activities going back for years and years and years, and previous publications. But my point, I suppose, is that blockchain for X is a little bit, it is not entirely easy and straightforward. It really depends on the facts of the situation. And again, you can be optimistic if in making your invention practically work, you're solving technical problems in a technical way.
Yeah, makes sense. Out of interest, do you know what patents activity there's been around the LLMs, that ChatGPT and so on? Have they managed to patent around those areas?
Off the top of my head, I don't know specifically what's happening with LLMs. I do suspect that there is quite a lot of patenting activity in this space. I'm aware that all the big AI companies and big tech companies more generally invest a lot of money in developing thickets of patents. So those are many relatively specific patents, and they're relatively specific because there's a lot of prior art out there in the areas that they're interested in. LLM specifically, for various detailed reasons, word processing tends to be a little bit difficult. Word processing can be seen by patent offices as related to not exactly business content, but related to the meaning of those words rather than the underlying technical processes. And it's those underlying technical processes that patent attorneys like myself have to focus on in order to get patents granted. So certainly possible to get patents in this area. I do suspect that there is a lot of patenting activity in that area. But just as a slight note of caution, word processing, natural language processing can sometimes be looked at a little skeptically by patent officers.
Yeah. So you said thickets, and I guess those big companies do that to effectively create big competitive moats where companies trying to innovate in their area would have it's like a minefield, basically, loads and loads of mines that you would have to probably break your strategy to be able to get anywhere near it. What are some of the other perhaps non-obvious reasons that your clients would be seeking patents with you?
Well, clear and straightforward reason, I guess, is to stop other people, competitors in particular, doing your cool stuff that you would really rather not other people do, because it would destroy your competitive advantage if they can take it.
Yeah.
The thicket idea is slightly different, and that's more of a deterrent, which big companies each have thickets, and that means that they don't sue each other, because if Apple starts to sue Google, for example, Apple probably infringe a few Google patents, and Google probably infringe a couple of Apple patents, so they call it quits, and it's
Right.
effectively who's got the bigger cannon or something like that. And if we've both
Yeah.
got the same size cannon, we might as well not
Yeah.
fight.
Yeah.
But that deterrent effect also works for SME companies. It's not the case that you should only patent if you ever see yourself actually suing someone in court. Frankly, for most of our SME clients, that's very much not a desired outcome, but they actually go to court and actually sue someone. In the UK in particular, that is unbelievably expensive to do. It's more about having this ability to threaten people, to deter people from doing your cool stuff. In a more general sense, though, there are other reasons, and in particular, the fact that you have a patent means you have an asset that can be used in various different ways. A patent could be licensed, and that can be a particular revenue stream in respect of technology that you don't mind if someone else goes and does, perhaps non-core aspects, for example, or in the event of the business pivoting and going in a different direction. Patent, like any other piece of property, patents can be mortgaged and doing various other exciting parts of things. And to some extent, it's useful just to have patents as a record that you are doing exciting technical things, in particular from the point of view of signaling to investors and also competitors.
Yeah.
And something that's really quite exciting that not enough people know about, frankly, in the UK and also many other countries, is this concept of patent box. And patent box is a government incentive scheme, which means that if you are generating revenue through patented products or processes, where patented means just that it's covered by a granted patent, then you get a cut in corporation tax in respect of that revenue. And that's, in some instances, can be a really, really big financial benefit. And it may be surprising to some folk to know that this is actually really quite obscure, despite the fact that you get a really quite big cut in corporation tax as a result in this. And what we try to educate of our potential clients and the industry more generally about is the fact that, even if you're not interested in patents really at all, even if you think in your particular industry that nothing you're doing is all that cool and you're not really that worried if competitors take it, it's still worth trying to get even quite a specific patent in many instances, just for the revenue in respect of patented products that you can make, that then causes this giant cut in corporation tax. That can be a real benefit.
Yeah. So it's kind of 20% to 10%. So effectively halving your tax bill, isn't it? Yeah.
Yeah, indeed.
I heard about a fintech company that was able to get a patent around its authentication on its mobile app. And what that meant was it was able to funnel really almost all its profits or revenues, because they all came through the app, through patent box. So it can be incredibly powerful. Obviously, you've got client confidentiality and so on. But you clearly have to publish a bunch of your stuff. Just wondering if you have any cool war stories like that of cool patents you've been able to help clients get that have made any big differences.
So a lot of our successes, frankly, are quite nerdy in nature. The ones we feel really proud of are the ones where we eventually managed to convince an examiner on an important argument that is quite subtle and that we've had some difficulty in, and get a nice, broad, widely applicable patent as a result. And more generally, what we do sometimes is quite nebulous in the sense that term relationships, we build up patent portfolios, and these patent portfolios, of course, have deterrent effect. So uh, they're great and they're really useful, but we don't really know how useful they're going to be, because of how useful they have been, because they've acted as deterrents. They've stopped others from doing things that our clients would rather not them do.
Yeah.
But we do also get involved in set pieces, and this is some of the most satisfying coups that we have. We have startup clients who exit with IP being a big part of that, with patents being subject to due diligence and things like that. Of course, clear commercial benefits resulting from patent box, and that's more in the category of nerdy successes, when we manage to get quite a nice specific patent on the on the patent law side of things that actually you can attribute a big chunk of revenue to, and so get a big benefit from. And of course, patents that that we've prepared, we've prosecuted, we've defended, and we've successfully litigated and or licensed. Those are quite big, quite high stakes, and those are really satisfying to be a part of.
Yeah, well, massive revenue and having a tax bill is certainly not nerdy. That's
No.
That's what we all aspire for. So, Max, as we get to closing, just wondering what commonly held beliefs about patents are most incorrect.
Well, when it comes to software,
Yeah,
straightforwardly, as we said at the start, that it's just not possible. That's the a really important one. Along with that, there's a really important one that a surprising amount of people aren't aware of when they first come to the process, is this idea of self-disclosure. So we talked earlier about this concept of novelty, about making sure that what you invent is, well, not making sure, but about whether or not what you invent is new over what's come before. Well, that's assessed as of the filing date of your patent application. And so a classic problem is that you file your patent application only after making your product available, after it launches, for example. And in that case, your patent application is not novel over your own invention. That is the subject of your patent application. And in which case it's straightforward, right? It's not novel. There's no argument to be made. We don't even get on to inventive step. And this is a real problem, of course, because quite often entrepreneurs are working on some cool product. They want to move fast. They want to get some market feedback. They launch at least some kind of prototype, and then after they've got some early feedback, they start thinking about everything else, including patent protection. And that can be a real problem from the point of view of obtaining useful patent protection. So it's not as if this is always a business killer. There are things we can do, in particular protecting developments on early prototypes, but a lot of the times it can be really harmful. So what we would always suggest is talk to a patent attorney really as early as you can, is the thing to do.
Yeah, the bacon and egg situation, as they say, is we need to get some of that validation before we can get the capital in that will be required in many cases to even really begin the conversation with a patent attorney. But
it's problematic. So
I guess the other trick is in getting the feedback to hold back, some of the good stuff, but manage to get the validation that you need. Cool. So final question. I'm sure you have a lot of not deliberate time wasting, but time wasting nonetheless, of people coming to you with, I've had this great idea, can I patent it? Which you smile, I'm sure is probably, you don't always smile. But what should people think about before even taking their time and important your time to have a conversation about patenting and patent eligibility?
Well, you say we get a few time wasters, and it's fair to say we do, but we would prefer it that way. We would patents are complex. It's not easy to understand for lay people. There are a lot of traps for the unwary. So what I'd say is, if you are considering IP protection, patent protection, I wouldn't hesitate, actually. I would come speak to us, or a patent attorney like myself, and
Mm.
we will be able to come up with some ideas that at least you can factor into the ongoing business planning, even if at that stage you don't right away go and file a patent application the next day. That may not be commercially possible, as you alluded to earlier.
Mm.
Um, so yeah, I suppose that's the overriding message that I'd like to push, that if you're in doubt, if you're considering things, talk to a patent attorney. More
Yeah.
generally, I think, if how to know you're in a zone of possibility, the thing generally to think about is if you are solving technical problems in a technical way, in using techniques that are not entirely non-standard and unexciting. If you're doing that, then I think I can reasonably say, you always have at least a reasonable case that you may be able to get some commercially useful patent protection. And of course, that's the other thing. There's no point of patenting something for entirely, some entirely moral victory, but you've got a nice patent that it's not commercially applicable.
Yeah.
And hopefully, if you get a good bunch of patent attorneys, they'll be able to speak to that as well and think about how patents factor into your ongoing business plan.
Yeah. Cool. Right, well, Max, thank you very, very much for that conversation. That was really interesting, really informative. Really appreciate it, and look forward to keeping in touch and keeping talking about our business with you.
Sure, pleasure. It was good to speak, Dylan.